Today we're talking about a topic that has thousands of green card holders across the country nervous before their next flight. How risky is it really to travel internationally if you're a lawful permanent resident under the current administration? In a recent development, the Supreme Court handed down a decision that changes the legal ground under your feet the moment you land back in the United States. This isn't just political noise or social media panic. It's a real shift in how Customs and Border Protection, CBP, can treat you at the airport. Who is affected? Potentially any green card holder, but especially those with any brush with the criminal justice system, even an old one. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. Let's start with what actually happened. On June 23, 2026, the Supreme Court ruled 6-3 in a case called Blanche versus Lau. Before this ruling, green card holders coming back from a trip abroad were generally treated as what's called returning residents. That meant CBP had to prove a very specific legal exception applied before they could treat you as anything other than someone who already belongs here. According to sources, that protection is now gone. After this decision, CBP can treat any returning green card holder as, quote, seeking admission, without needing to prove that exception first. What does that mean in plain English? It means the government no longer has to prove you're inadmissible. Instead, the burden flips onto you, the green card holder, to prove that you're not. This is a big deal because it touches something called crimes involving moral turpitude, or CIMT. Reports suggest this category now applies more broadly than before, covering conduct regardless of when it happened, not just within the first 5 years after you were admitted to the country as previously required for deportation cases. In practical terms, an old arrest, a dismissed charge, or even a case that was expunged at the state level might still show up in CBP's databases and trigger a much closer look. So who is actually at risk here? Legal analysts suggest the highest risk category is green card holders, with pending criminal charges, especially ones that could be classified as a CIMT, but it doesn't stop there. Anyone with a prior conviction, even an old one, even one that felt fully resolved years ago, is now in a more exposed position. Immigration experts note that a dismissed case doesn't automatically create a problem, but it can still surface in border databases and lead to what's called secondary inspection, which is where you're pulled aside for detailed questioning. Beyond criminal history, there are other long-standing risk factors worth knowing about. If you've been outside the United States for more than 180 days in a row, that alone can raise questions at the border. If CBP believes you engaged in illegal activity while you were abroad, that's another flag. And if you had an open immigration court case when you left the country, that follows you home too. What makes this case different from previous immigration crackdowns is that it's not coming from an executive order or an agency policy memo that could be challenged or reversed relatively easily. This came from the Supreme Court. That gives it a level of legal permanence that immigration attorneys are taking very seriously. Advocacy groups warn that in a worst-case scenario, this ruling gives CBP the tools to reclassify large numbers of returning green card holders at once, funneling more people into removal proceedings than before. And here's a detail that should concern anyone who travels frequently for work or family. Officials note that green card holders processed this way can have their physical green card, the I-551, confiscated right there at the airport. In its place, you may be issued a temporary document, sometimes just a stamp in your passport, that is only valid for a limited time. What this translates to is a cascade of everyday problems. Suddenly, your job, your bank, your housing lease, your insurance, or your kids' school paperwork might not accept your documentation the way they used to, because you no longer have the physical card in hand. Now here's something every single green card holder needs to hear clearly, whether or not you think this applies to you. If CBP detains you at the airport, they may present you with a form called the I-407. Do not sign it without speaking to an immigration attorney first. This form is a voluntary surrender of your green card. Signing it under pressure, in a stressful moment at the airport, can waive your right to a hearing in front of an immigration judge. CBP cannot legally strip your status on the spot without due process, but that protection only holds if you don't sign it away yourself. As a green card holder reading headlines like this, it's natural for this to feel overwhelming, maybe even a little frightening. However, before jumping to conclusions, it's worth understanding exactly who this touches most directly. If you have no criminal history, no pending charges, and you haven't been abroad for an extended stretch, your day-to-day risk profile has not changed dramatically. Despite these changes, most green card holders traveling for a family visit or a short vacation are still going through the airport the same way they always have. The real question is whether you fall into one of the higher risk categories. And if you're not sure, that uncertainty itself is a reason to get informed before you book a flight, not after you land. Immigration experts also point out that this ruling has ripple effects beyond individual travelers. Employers with international business travel programs are now factoring in the possibility of delayed or complicated re-entry for employees who are green card holders, particularly if those employees have any unresolved legal history. Companies are being advised to build in contingency planning for these situations, which tells you how seriously the legal community is treating this shift. So, what should you actually do with this information? If you have any past arrest, conviction, dismissed charge, or reduced charge, even one that feels ancient history, talk to an immigration attorney before you travel internationally, not after you're standing in a CBP line. Carry documentation related to any dismissals or resolutions of past legal matters. Know your rights around the I-407 form before you ever set foot near secondary inspection. And if you're planning an extended trip abroad, especially anything approaching that 180-day mark, build in extra time and paperwork buffer for your return. To put this in perspective, international travel for green card holders isn't off the table. But the margin for error has shrunk, and the consequences of getting caught in a gray area have grown. Many fear this is just the beginning of broader changes to how permanent residency is treated at the border, and it remains to be seen how lower courts and future cases will shape the practical application of this ruling going forward. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.